Good morning, and thank you for the invitation to address this working group on land reform. I am Muhammad Azhairan, and I am a land law specialist with specific experience of the working and reforming of England and Wales land registration system. The system of land registration under the Land Registration Act 2002, or known as LRA 2002, was introduced to simplify conveyancing and provide certainty and clarity title to land. One of its basic policy principles is the mirror principle, which has the curtain and insurance principles in common with forming the legal structure of registered land. Nevertheless, still room for advancement. Today, I will set out these principles, assess their impact in practice, and suggest reforms to make the system fit for purpose in the 21st century to ensure accessibility, efficiency, and transparency to all users. So let's move to the first question. What is the mirror principle? Deep in the heart of registered land law is the mirror principle, a building block principle that imagines the land register to be an exhaustive and current record of all the legal rights and interests that touch and concern a plot of land. The idea is that what appears on register should be the whole legal reality, no more, no less, so that buyers, lenders, and others can have reliance on the register and act without further investigation. This principle promotes certainty, reduces the cost of transactions, and aims to facilitate conveyancing by removing the need for buyers to examine historic title deeds or undertake extensive inquiries. The foundation of this principle was clearly set out in the case of Fraser and Walker, 1967, which is the landmark ruling of the Privy Council, whereby it was held that the register shall be evidence of title even where registration was caused by fraud, provided that the purchaser is in good faith. In that case, the court ruled that the integrity of the register has to be maintained, and innocent buyers cannot be put to prejudice on account of acting on its strength. In theory, this is a good basis for public confidence in the land regime, but in practice, the mirror is less clear and complete as it is intended to be. So, to the next question, which is the second question. Along with the mirror principle, there are two more doctrines about assisting the operation of the register, which are the curtain principle and the insurance principle. The curtain principle is based on the idea that certain equitable interests, especially those under trust, can be behind the curtain and are not necessary to be registered. The purchaser is not obligated to look into these hidden interests because they are intended to be overreach, that is detached from land and transferred to the purchase money to two or more trustees. This was demonstrated in the case of City of London Building Society and FLAG 1988, where the FLAG's equitable interests in the home were lost when the house was sold, since the purchase money was taken by two trustees. Although their equitable interests were genuine ones, they no longer attached to the property itself. This mechanism is designed to facilitate transactions and protect buyers but can risk leaving behind vulnerable occupiers whose rights cannot be seen on the register. The next principle, the insurance principle, is designed to remedy the unfairness of inaccuracy on the register. If someone is deprived of loss as a result of the error on the register, they are likely to receive state-funded compensation. For example, in the case of Swift First Limited and Chief Land Registrar, 2015, the lender lost its registered charge due to a fraud on the title. Compensation was ordered by the court, determining that the register users must be shielded from the consequences of fraud or administrative error. Together, these laws are intended to make the land system calculable, fair, and economically sustainable, but in practice, they are routinely bested by practical and legal shortfalls. Move on to the third question. In theory, the mirror principle is a tidy, handy solution, but in practice, the mirror is not so clean or complete as it could be. Let me point out three issues. Firstly, overriding interests, which we can call the cracks in the mirror. One of the key flaws in the mirror principle is that there are overriding interests. These are interests or rights which bind purchasers irrespective of whether or not they are recorded on the register. They are addressed in Schedule 3 to the LRA 2002 and include short leases, which is less than 7 years, some easements, rights of person in actual occupation. The key case here is Williams and Glyn's Bank and Boland, 1981. On this case, a husband was the registered proprietor of the house where the couple were residing. He had charged the house, but the wife was in occupation and had contributed to the finances without disclosing it to the bank. Her equitable interest combined with her occupation gave her an overriding interest. The mortgage by the bank was overreached. What this serves to emphasize is that the register can invariably be taken to be complete. The fact that there may be overriding interest gives rise to uncertainty and frustrates the promise of an up-to-date and reliable register. For purchaser, the implication is that what you are told on the register is not necessarily the full picture. You might well still want to carry out more investigation, particularly as regards occupation and use of the property. Next one, unregistered land, which we can call the missing mirror. Still more fundamentally, the mirror principle cannot operate where the mirror does not exist. That is the case with unregistered land, which still accounts for around 10% of land in England and Wales, despite this proportion varying by region. Unregistered land is governed by older rules. There is no central register showing where the land belongs to or what burdens there are. Instead, a buyer must trace ownership from a series of deeds, often many decades in length. It is slow, costly, and risky. It increases the risk of fraud and places a huge burden on professionals and individuals alike. It also leaves us with an imbalance. Some of the most disadvantaged landowners, such as rural villages, small religious communities, or elderly householders, are likely to be the least likely to have registered their land and most likely to be unable to prove their title if things go wrong. The continued existence of unregistered land in 2025 is quite simply a structural weakness in our property system. Last one, accessibility and complexity. Even if land is registered, the register can be closed to non-experts. Technical legal terminology is used in most of the entries. Others refer to the unregistered documents or cross-reference titles. Leases, covenants, and easements could be registered in language difficult for the general public to understand. This opposes the principle of accessibility in a system meant to be transparent. It is disturbing that citizens of the general public cannot understand their own property titles without resorting to paying for professional advice. Now we move on to the last question about reforms. In order to meet the demands of the 21st century, I can suggest four broad reforms that will render the land registration system more useful and credible. The first one, attain universal registration. Priority should be given to the registration of all land in England and Wales. A strict statutory time limit must be introduced with high value, high impact property as a starting point. Comprehensive registration would be in the public interest promoting policy objectives like housing constructions, conservation, and anti-fraud initiative. Second, redesign overriding interests. The overriding interest law, particularly the rights arising out of actual occupation, must be examined and curtailed. Occupiers should have a duty to register their interests under notice when they are aware that a transaction is in the works. This will enhance the transparency within the system while protecting weak parties. The third one, increase digital access. The land register must become a fully digital interactive system. A geographic information system register with data layers would make it easier to determine ownerships, boundaries, limitations, and related information. It would be enable easier access for lawyers, developers, community groups, as well as members of the public. And lastly, enhance legal education and outreach. So the public must be empowered to understand and protect their interests in land. The land registry must make an investment in clear, accessible content, including guides on co-occupation, beneficial interests, occupation rights, and registration procedures. This is especially crucial for people like unmarried couples or multi-generational family members. So we have come to an end. To conclude, the Land Registration Act 2002 was a significant improvement in land law, but the system is still to attain the broad aims of accessibility, efficiency, and transparency on a consistent and reliable basis. The continued existence of unregistered land, the impact of registered rights, and the complexity of the overall legal regime undermine user confidence and the effectiveness of the register. In an effort to ensure the system is truly fit for the 21st century, the reform should target universal land registration, improve digital infrastructure, improve regulation of secret interests, and more public education campaigns. These are essential measures to establish a land registration regime that is not only legally robust but also inclusive, accessible, and trusted by all those who have occasion to use it, whether practitioners, policymakers, or members of the public. So that is all from me. Thank you for listening.